What level of mental capacity do you need to be able to execute a deed? Hi, I'm Darren Findling of the Probate Pro, and this particular issue was just addressed by the Michigan Court of Appeals. The case is the estate of Anna Brudick, and in this particular case, Anna had signed a deed to her boyfriend, conveying half of her interest in the property. Now, after Anna died, her daughter filed a case with the probate court, opening the probate estate and asking the court to determine that the deed was invalid because Anna lacked capacity. Coincidentally, about 4 months before the execution of the deed, Anna's daughter had visited the house and found it to be in terrible disrepair, her mother in poor condition, and she helped coordinate getting Anna evaluated by a doctor. The doctor's evaluation was about 4 days after the execution of the deed, and it supported the fact that Anna was in diminished capacity. And 6 months later, there was a full neuropsych report that also supported a lack of capacity. So the Michigan Court of Appeals addressed the ruling from the probate court that ruled that Anna's capacity was lacking when the deed was executed. The Court of Appeals said that you must show by a preponderance of evidence that the person executing the deed had sufficient mental capacity to understand the business in which he or she was engaged, to know and understand the extent and value of the property and how he or she wanted to dispose of it, and to keep these facts in mind long enough to plan and effect the conveyances in questions without prompting an interference from others. So this standard of capacity was set forth, and the Court of Appeals ruled that the lower court ruled properly and affirmed the ruling. So again, to have sufficient mental capacity, the person must understand the extent and value of the property, understand the business of which they were involved in or engaged in, which is the executing of a deed, know how they wanted to dispose of it, and to keep these facts in mind long enough to plan and effect the conveyance in question without prompting an interference from others. I think that's a really interesting piece of this ruling. So, capacity has been determined for the execution of a will. If you've got questions about probate-related issues, visit us at theprobatepro.com or call us at 833-PROBATE.